Good morning and welcome everyone. Thank you for joining our annual Employment Law Seminar. It's great to have so many of you join us today, and a particular warm welcome to our clients who are joining us as well. We've got a jam-packed agenda for you, and to give you a feel for how we're going to spend the next couple of hours, this is how we will structure the session. So the first session is going to be the April pay surge, covering statutory pay rates and payroll updates. Then we'll dive straight into the Employment Rights Act 2025 reforms, and to keep it practical, we'll be asking for your involvement. And then we'll move on to session 3, where we'll look at some real-world 2025-26 rulings. Victoria will present the scenarios, and we want to hear from you. How would you rule before we reveal the actual outcome? So a little bit different this year. And then we're going to move on to the 2027 horizon to preview the upcoming law for 2027, some case judgments and trends before wrapping up with a live Q&A. And then we'll conclude with highlighting how you can prepare your business for change. What we'll do as we move between the sessions is highlight your call to action, key priorities for taking away from today's seminar. Before we start, we've just got a few quick housekeeping notes to help you get the most out of this morning. So we're just going to go through a few key points. First of all, let's introduce ourselves. So my name is Sue Watson, and I head up the HR Solutions Division as the Operations Director. I'll be discussing the employment developments for 2026 from a strategic and operational perspective. I'm joined by Victoria, an HR Knowledge Manager, whom some of you will know from our webinar events. Victoria will be guiding us through all the employment developments we can expect to see this year. A little bit about us, HR Solutions. We're very proud to have received the FIFO Platinum Trusted Service Provider for the 3rd year in a row at Platinum level. All of our teams are either CIPD or CIPP qualified, the ones that deliver these services to you. We do contribute to external government consultations and forums. Victoria and I have had many a happy afternoon considering how we respond to those on behalf of our clients. We also offer a variety of packages to suit your needs. From dedicated HR consultants with team-based support as well. We do support many HR consultants and in-house HR people as well. So we work on many levels. We also maintain HR documents in compliance with this legislation that's coming in. There's lots of it this year. And we can offer legal representation and award payment coverage for UK tribunals as well. And as well as all of that, that's all the operational side of things, we also look at the HR strategies and aligning HR strategies with business goals. So we see ourselves as big enough to help, small enough to care. So first of all, we're going to start with launching our first poll just to hear a little bit about you and get to know our audience. We find it helps us steer the conversations as we go through, so as we understand where you are all from. So I'm going to launch the first poll, which is, how would you describe your business? It's just distributed at the moment, so hopefully it'll come through. Yeah, here we go. They're coming through now.
Brilliant.
There we go. I'm going to close the poll and share those results. So we've got majority in the 50 to 249 employees. It's interesting when we look at this and we compare it from our usual webinar attendance, because the employment law seminar is usually a little bit different. So we have got quite a good number from the larger employees and slightly less from the micro, whereas it's often the other way around.
Yes.
on the webinars. So I will hide that one, and then I'll launch just one more at this stage, which is, who looks after human resources in your business? I think it's distributing that one now.
Okay.
Here we go, they're coming through. I think from the sizes of the businesses that have joined us today, it's looking like this is going to reflect that particularly. So I'm going to close and share those results. So there we go. Mainly in-house HR team and in-house HR managers, but also we have office managers, business owners, which is where a lot of our work is. And we've obviously got some outsourced HR teams as well on board. So here we go. Let me just hide that.
Yeah.
And then we're now going to just look at a few practical essentials for you. So we are expect to finish around noon today. We won't go over that, being as it's such a kind of long session. You will receive a frequently asked question set after today's event. We'll be highlighting throughout how you can access lots of free tools and handouts to accompany the webinar. You'll also be provided with a copy of the slides and a link to the recording afterwards. So everything that you could need following this, we will be making available to you as soon as possible after the event. Your participation is really what makes these work. So we'll be using live polls to see what's happening in your organisations, doing some quick pulse checks to see how you're feeling, and of course taking your live questions throughout. All of this helps us steer the conversation, but more importantly, it lets you see how other employers are handling these same challenges. And for you, knowing you're all in the same boat can be incredibly reassuring. So please do get involved. That's what makes the session for us. So how to ask us your questions? Then through your control panel, you'll see the panel for questions. If you submit that to us, we send them throughout the seminar today, and we will read out as many as we can at a couple of options during the session today. So, and we'll capture all the key ones in a FAQ at the end as well, and make that available to you. So thank you very much. So without any further ado, I'm going to hand over to Victoria so that we can begin our first session.
Thank you.
Sorry, no, I think yes, carry on.
No, that's fine. Thank you, Sue, and welcome everybody. Would like to reiterate what Sue said earlier. Welcome to our annual seminar event. So now we've settled in, we're going to first look at the numbers, and we all know that every April brings statutory increases, but for this year it does feel particularly significant. So before I start going through the statutory changes and the numbers, I just want to ask 3 quick polls. So I'm going to ask Sue to launch these polls. And as I said, your engagement in these are really valuable because it helps everybody to see how other organisations are thinking or what they're doing. So please join in. So the first poll, let's see.
Just coming through now.
Oh, brilliant. And it's around the use of umbrella companies.
Interesting developments around this, isn't there?
Yeah.
Actually quite a decent number of you actually use them. So I think as we get more international, it becomes more of a thing, doesn't it?
Yeah.
Okay, I will close the poll and share those results. So there we go.
15%.
She's quite a lot.
Yeah. Yeah.
And then you've got another one, which
the
is...
second one is, do you operate a holiday year that runs between the 1st of April and the 31st of March?
I think the polls are kicked in quicker as well today.
That's good to see.
Okay, I will close and share that poll.
Lovely. And what do we have?
So 26%.
Wow. Okay. Yep.
Okay, so some interesting information for you coming up.
Yeah. These are intriguing poll questions, and I'll explain shortly. And the last poll in this part is around bank holidays.
Having just been about to calculate somebody's holiday entitlement due to being on maternity leave across the 2 holiday years, I'm sympathising with you all on this one.
We love holidays, don't we, in HR?
We do, we do.
As in calculating and obviously taking them. So,
okay, I will close and share the results of this one. There we go. So, yes.
okay. So yeah, what I'll cover shortly then, for those of you that have said no, we've got some interesting information coming up. So without further ado, I'm going to move the slides on and we'll get looking at the numbers. So what you'll see on this slide here are the key statutory rates for the April 2026 financial tax year. Don't worry about scribbling everything down. You'll get a copy of the slides, and also after the event there is a handy one-page key payment summary that we'll be making available, so that'll be for you afterwards. But just to sort of bring the highlights, so if we look at statutory sick pay, that's being increased, so a new flat rate will become the 123.25. I am going to cover SSP later on in the seminar because, as you'll know, we've got significant developments coming in. Family leave rates, whether it's maternity, adoption, paternity, the flat rate there is rising to £194.32. And then, of course, we have the annual national minimum wage increases, as you'll see on the screen here. And actually, there's been some talk in recent weeks about whether the government should delay increases for young workers. But as it stands today, this is what the rates are set to become. And then the final box there is around apprentices. If you employ apprentices, then just be aware of how the rates are going to be changing. And of course, rates depend on the age and on whether somebody's in their first or second year. So this is going to be really important to make a note of the different dates as well, because compliance will come in at different dates depending on which payments you're applying, as you'll see from the slide here. So developments, and so while we're on the subject of figures and finances, there are actually 4 other key areas we need to keep on our radar for 2026. These might seem like technicalities, but actually they have a direct impact on your tax planning and compliance. And so if we look at, first of all, the van and fuel benefits, we're going to see an increase in the flat rate figures for these benefits. So if you provide company vehicles, you'll need to factor in the new values into your calculations for the new tax year. Now, we've asked a couple of poll questions about holiday years and bank holidays. This is one to watch closely. And so for those of you that indicated that you have the holiday year April to March, which is, I think, 26% of you, then we actually have 10 public bank holidays in England this holiday year. So if your holiday year does follow this, then if you're not prepared, it will become a headache and a legal issue, because it all comes down to how your contract of employment is worded. So if your contract says to the employee you're entitled to 20 days plus bank holidays, given that we've got 10 this year, you're legally tied to giving every bank holiday that falls in that current holiday year, meaning you'd be paying for those extra days. Whereas if your contract says to the employee you're entitled to 28 days, including bank holidays, then you have a cap here. And that means you can include those extra days within that 28-day total without increasing your costs. So it's small phrasing, but it has massive financial implications depending on which way your contracts are worded. So definitely now is a time to audit your contracts, because you don't want to be in a position of breaching any contracts and therefore receive those breach of contract claims or the unlawful deduction of wages if you're not giving payment if it's a statutory entitlement. So that's really significant. Then if we think about payrolling of benefits, then the move toward mandating payrolling of benefits is gaining the momentum. We did have a delay, and so now it means it's from 2027 where it's going to be mandatory. But it is time now to start thinking about how you move your processes into your real-time payrolling to stay ahead of the curve. And actually from April 2026 it becomes voluntary, but as I said, April 2027 is when it becomes mandatory for the payrolling of benefits. And then if we think about the umbrella companies and the developments in that year, so 15% of you said that you use umbrella companies. So we're keeping a close eye on these regulations. There's quite a bit of information I'm going to cover shortly. Don't forget you've got the question panel as well, so if you do have any questions as I go through these, do reach out. So this is going to be a massive change. There are currently around 700,000 people in the UK employed in this way, and so there is a good chance that some of you are using them via recruitment agencies or for temporary staff, and obviously we've got 15% of you that have indicated you're using them. So as it stands, umbrella companies acting as the employer are the ones who are legally responsible for deducting PAYE and national insurance, and if they don't, then they have the HMRC is going to them to have that matter addressed, and it's their problem, not yours. But that is all changing from the 6th of April. A new chapter is being added to the tax legislation that introduces joint and several liability. So what that means in simple terms is if an umbrella company in your supply chain fails to pay the required tax, HMRC can now legally, or will be able to legally, come knocking on your door or the door of the recruitment agency to demand that money instead. So this is really important because you can no longer just assume that umbrella companies are being compliant. If they default, the financial burden could land right back on your desk. So it makes it absolutely critical to audit your supply chain and just ensure you're only working with reputable, transparent partners, because it's no longer just a payroll check, it's actually a significant business risk for employers. So as we come to the end of this first section, which is all to do with payroll, we're going to just share with you our calls to action. So first of all, we recommend updating your pay rates for those workers on the national minimum wage. Audit those who are on the national minimum wage to check, has anybody moved up an age bracket? With the increases to the national minimum wage, then it's really important that you review any pay differentials if there are. And so how do these increases impact pay gaps in your organisational structure? Because that could very well have a knock-on implication for how you pay others in the organisation. Identify anyone currently on family leave or due to start a period of leave in April. Check how you manage bank holidays if you operate an April to March holiday year. Audit your supply chain and check your systems can deal with all of these changes and monitor how your systems are dealing with these for ongoing compliance. To the right of the screen, you'll just see a QR code there. So if you're currently operating your own payroll and want to find out more about our payroll services, then obviously please do get in touch and we can explore that with you. So now we're moving into the second session, which is all about the legislative shift. And that is the meat of today's session, because we're going to be looking at the Employment Rights Act. So just to let you know, there is a handout to accompany this section as well that will be provided to you after the event. Before we dive into the specifics, it's important to set the context. what we're discussing today is a massive overhaul, the biggest in a generation, and because of that, it's still very much a work in progress. So there's a few things that I think we need to keep in mind as we go through today's seminars. So the dates we're talking about are expected dates, not fixed. So the government has given us a roadmap, but these dates aren't necessarily set in stone. And in fact, just a month ago, we saw some slight amendments to the road map and the timeline by the government. So the government do have the power to amend that timeline. So while we're planning for certain dates today, we have to stay agile as a business in our preparations. I guess one thing to sort of indicate is nothing's going to be brought forward. If anything, it'll be pushed back. Another critical and important factor is the fine print of all of these reforms is still being written. So most of the reforms aren't ready to go because they need formal consultations, for which we've already got open and running at the moment. The reforms will need specific regulations drafting that gets developed on the back of consultation feedback, and we're going to need more or new codes of practices and amended existing ones too. So we know at this stage the direction the reforms are moving in, but the exact how-to for employers is still being finalised in many areas. And then finally, because of time restrictions for today, there are simply too many reforms to cover every single one in our session. So we've handpicked the most significant changes that are going to affect the majority of you in attendance. But don't worry about missing out on other bits. We do have a comprehensive guide to support the session today, where you'll find all of the reforms that are coming in and the timeline. So please don't worry about that. Actually, what's quite handy is our timeline, and do share it with your team members, your other managers in the business, because actually just having this to the side of your desk is really good reminder to of where to focus and what to action at any point in time. So again, this will be a handout. It's also available on our website, but it's a very clear visual, as you can see, and it goes on to 2 pages, reflective of the volume of reforms that we're dealing with. So for this section, I'm looking at 2026 only. And as I said, I've picked out a few that I think most people will be affected by them. So trade unions, SSP, family rights, etc. And we're going to start off with the trade union reforms. And if you're thinking that, oh, we don't have a union, it doesn't really apply to us, actually, we'd urge you to find out more about the reforms in general, because actually this area is an area that could significantly impact your business, because what we'll find from many of the reforms is that they have the potential to increase recognition, which I'll come on to explain. So the purpose of today, this is just a summary at a glance. There will be a handout to support this and giving you more detail, but really the Employment Rights Act is essentially opened the door for unions to enter workplaces where they've never had a foothold before. So we know the government's goal is to modernise industrial relations, and they're doing it in several ways that affects every employer. So as I said, a handout will share the full details, but essentially what I guess the message for today is from a key reform from October 2026, it's going to become a legal requirement for employers to proactively inform every worker of their right to join a union. So this is for all employers, regardless of whether you're recognised or not, and it will be something that has to go in the contract of employment. It's not just for new starters. It's a day one statement, but it must be given to all workers about their right to join. Secondly, there's going to be a big shift in terms of the right of access. Unions are going to be gaining a new statutory right to enter your workplace. And when we say workplace, it could be physically and digitally. And the purpose of which is to be able to meet their members, but also recruit workers as well. even if you don't recognise a trade union in your organisation, they will have a statutory right to come on site. And so you may soon need to negotiate an access agreement to facilitate this. So this is a big significant development for employers. When it comes to recognition, the bar for union recognition is being lowered significantly. So the old requirement for 40% of your entire workforce being needed in order to get the recognition is going to be abolished. Under the new reforms from October, for recognition, a union will only require a simple majority of those who actually vote. So this brings me back to what I was saying a moment ago. The reforms, there's lots of them, but the key messaging today is really about how the landscape is making it easier for or greater recognition happening within organisations, and those employers that aren't recognised are going to be potentially impacted by these reforms too. So the best strategy now is to ensure, I think, your internal communications are strong, you have strong employee engagement, because what you're trying to ultimately do is encourage your workforce to continue their correspondence and communications with you directly. That's your best strategic position. Of course, if you've got a work environment that's where there's a culture of low engagement, then, or you've not necessarily got the right communication mechanisms in place, these give opportunities to unions to come in and try and address that, and then to give the workers a way of communicating. So if you can really tackle your workplace culture in terms of engagement, motivation and communication, that's really a key strategy now for everybody. And actually, you know, there are a lot of reforms coming on in this area, and actually we do have a webinar coming up in May where we're going to be talking about how to navigate these trade union reforms, and we're going to talk from it from a very practical perspective for employers. So you'll see the QR code there. All our webinars are free to come along to. They're an hour, so please do come and join us for that, and we'll talk through trade unions. So now to SSP reforms and what this means, particularly from an absence management perspective. So again, we've got a handout. So and in that handout, there'll be some examples of how to calculate SSP and some guidance for the implications for the changes that are coming in. So we are looking at one of the most immediate changes for payroll and management teams. There is a complete overhaul of SSP, and it's happening on the 6th of April. And there were several big reforms happening. First of all, we're saying goodbye to waiting days. So as you know, currently, the first 3 days of an illness are unpaid from a statutory pay point of view. But what's going to happen moving forward from the 6th of April, SSP is going to be payable from the very first day of absence. Secondly, we're going to see the earnings threshold for the purpose of who qualifies abolished. So at the moment, employees must earn at least £125 a week to qualify. That's going. It's being removed entirely. And what that's going to do is bring an estimated 1.3 million additional low-paid workers into the statutory sick pay system. So to manage that, there's going to be a new 80% rule. So for those low earners, the calculation is going to be either 80% of the average weekly earnings, or the flat rate, which is increasing, as I said earlier, to 123.25, whichever is the lower. So all workers, regardless of level of earnings, regardless of hours of work, will be eligible for SSP, assuming, of course, they're following all your absence reporting procedures and notifications, etc. And there'll be that new method for calculating SSP when somebody is a low earner. But from an operational point of view, this will have obviously significant implications. First of all, financially and from a payroll, it's going to lead to increased costs. We know from the government, their own research, that they estimate an average increase of about £15 per employee per year. However, obviously for those businesses that do have higher absence rates, that figure could look quite different. And so it also brings increased payroll complexity, especially as you manage that new 80% calculation for low earners. And secondly, policy and compliance. You're going to have to look at your paperwork. It's time for an audit and oversight check of your existing contracts, policies, staff handbooks. If your current contracts explicitly mention waiting days, then obviously they need changing. So now's your opportunity and time to update your policies, procedures and contracts of employment. You'll also need to prepare for new reporting requirements to stay on the right side of compliance and enforcement, which I will come on to later. And then we need to think about workforce management, because we may see a possible increase in short-term absence now that the financial barrier for taking a single day off has been removed. It's going to make workforce planning more critical than ever. And the most important steps that you can take right now is to train your line managers, because your absence management procedure is going to be critical. Your line managers are on the front lines. They need to understand these changes so they can ensure that absence is managed, and actually all the steps that form a typical process, like your return to works and self-certifications and all of that, are handled correctly, because all of these are deterrents and helping ultimately managing absence. For those of you who are familiar with our webinars and attended one, we did do our SSP reform webinar back in January, I want to say. And so you can get the recording on demand. So check out the QR code and you can watch back our dedicated webinar on SSP and how you can prepare your business for the reforms coming up. So now we're going to turn to some of the most heart-led changes in the new legislation, which is the transformation of paternity and parental leave. And I guess from the 6th of April, we're going to see changes to both paternity and unpaid leave, because they're going to become day one rights. Currently, a new dad or partner must work for you for 26 weeks before they can take paternity leave, and an incredible 1 year for unpaid parental leave. But from the 6th of April, they'll be abolished. One very important detail for you and your finance teams is that the rules for statutory paternity pay are not changing. So while they can take the leave from day one of employment, they still need the 26 weeks of service to qualify for this statutory pay element. It's a bit of a quirk in the law, can lead to possibly confusing conversations. So it's really worth ensuring your managers are prepared and understanding this slight difference with that particular entitlement. We're also going to see paternity leave become more flexible, because we're going to have the loophole removed that currently exists. So right now, if a parent takes shared parental leave first, they actually lose their right to paternity leave, because you can't tag it on the end of shared parental leave. But from April, that's going to change, and actually parents will be able to take their paternity leave either before or after, giving them therefore much more flexibility in how they bond with their new arrival. And then finally, perhaps, and something that's probably gone under the radar and it has crept in quietly, I would say, and it is the most significant passionate change, and that is the new bereaved partners paternity leave. And so what this is going to do from the 6th of April when it comes in is, in the very tragic situation of a mother or primary adopter passing away within the first year of a child's life, then the partner will have a statutory right to take up to 52 weeks of unpaid leave to care for the child. It is a day one right when it comes in, and it's about ensuring no one's forced to choose essentially between their job and their child in such devastating circumstances. So that's been introduced as a new leave from the 6th of April. So harassment, we do need to talk about the major shift in how the law views workplace harassment, because you'll know that since October 2024, employers have had a duty to take reasonable steps to prevent sexual harassment. Now, under the Employment Rights Act, that bar is being raised even higher, because from October, along with some of the significant developments, that bar will become all reasonable steps, as I'm going to come on to in this slide. So just to clarify, from a technicality perspective in law at this moment, someone can claim harassment on any other basis of the protected characteristics, and they are your age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation. And that's general harassment. But they can then also claim as a specific legal recourse sexual harassment. And sexual harassment is, as the phrase indicates, is limited and amounts to purely conduct that is of a sexual nature. What we have is a situation at the moment where, to prevent general harassment, the legal duty on employers is that they must show they took all reasonable steps to prevent it from happening. That area of the law is fine, it's not changing, but I just want to give you some context. What we are going to see change is the legal standard for sexual harassment, i.e. conduct specific to the behaviour that is of a sexual nature. Because currently the legal obligation is to take reasonable steps to prevent sexual harassment, which is out of kilter with the general harassment legal test, which is all reasonable steps. Hopefully you're keeping up with me. So the legal duty is going to be widened for sexual harassment claims from October, and you're going to be obliged to take all reasonable steps to prevent sexual harassment from occurring during the course of employment. So the law is changing one small word, but that one small word carries a huge weight. So we're moving from taking reasonable steps to taking all reasonable steps, meaning you're going to have to justify why any step you didn't take was considered unreasonable. It's a much, much higher burden of proof. It is going to require regular risk assessments, fresh training, and that visible culture of zero tolerance to any sexual harassment. So that's a big change. And then finally, when we think about third parties and our workforce interacting with third parties, there's no specific direct claim that they have to address third party harassment. But from October, there's going to be a new type of harassment claim introduced for third party harassment. And again, to bring it in line with both general harassment and sexual harassment, the legal duty will be on you to take all reasonable steps to prevent harassment by a third party. So a third party is your clients, customers, patients, if you work in the care sector, health, students, if you work in education. And this new type of harassment claim, third party harassment, applies to all protected characteristics, not just sexual harassment, which is what we hear a lot of in the news when we talk about these changes. This particular one is going to cover all general harassment claims. So as I said, that's all your age, disability, gender reassignment, etc., etc. And then just a couple of other points on this. And hopefully this is good news because it's quite unusual to have, but we are expecting regulations sometime next year that specify what is meant by all reasonable steps in preventing harassment. Now, we do have a bank of case rulings already to help guide us, but I think having regulations will be welcomed by employers, because as I said, there's not many areas in employment law where we get told what is likely to be reasonable. So that's something to look out for. And then the other development where we don't have a date yet, but I just want to flag because we're talking about this particular reform, non-disclosure agreements. So any that relate for harassment and discrimination in employment agreements, they're going to be unenforceable under the Employment Rights Act. But as I said, we don't have the date for that as yet. We're now moving to how employment rights to be enforced, which will be changing dramatically. And you've probably heard of some of these things, but first of all, we've got the Fair Work Agency. This is one of the biggest game changers in the legislation. It's launching in April this year. And I say April, it's only just probably 3 weeks away, isn't it? And it will be established gradually, but essentially it will be established from next month. And the Fair Work Agency is designed to be a one-stop shop for employment rights enforcement, and it represents the most, as I said, significant shift in employment law enforcement probably in a decade. And the new enforcement body will oversee certain employment rights, holiday entitlement, national minimum wage, SSP, and additionally there's going to be a new legal requirement to maintain accurate holiday pay records and pay in lieu of holiday records, so that it mirrors SSP record keeping obligations too. But let's just spend a little bit of time on the Fair Work Agency. And so I've broken it down into 3 sort of areas. It is one single enforcement power. So as I said, it's going to be responsible for holiday pay, SSP compliance. It's going to bring together existing bodies that we already have, HMRC's National Minimum Wage Unit, the Employment Agency Standards Inspectorate, the Gang Masters and Labour Abuse Authority. So it's going to be a one-stop shop, if you like, encompassing all of these legal requirements. They're going to have tough powers. They're going to have a single set of powers that will include the ability to inspect workplaces, so being able to enter your premises and require you to produce any relevant documents or evidence, or even speak to your employees. They'll be able to issue notices of underpayment if they find an error, requiring you to pay back workers for up to 6 years of underpayments. They're going to be able to have the powers to apply hefty penalties. So on top of back pay, they can issue a financial penalty of up to 200%, not 200,000, 200% of the underpayment, but that is going to be capped at £20,000 per worker if you pay within a certain timeline, and then it's going to be reduced. But it still means you're going to be paying hefty penalties. And they're even going to have the power to charge you for the cost of any investigations they're doing if you're found to be non-compliant. Which brings me on to record keeping, and it's probably a really critical point. It is a really critical point for your team today, because failing to keep adequate records in all these aspects that fall under the remit is essential. You're going to be required from April to maintain records for each worker about the holiday pay, as I mentioned, and we already have obligations in response to SSP payments. So there is going to be a real focus now on making sure your records are thorough, accurate, and obviously relevant. But the Fair Work Agency is just one small element of enforcement. It's part of a perfect storm for employees, if you like, because we've got to think about employment tribunal reforms, and there are several significant ones. And while the Fair Work Agency will handle enforcement pre-tribunal, and incidentally they will be able to bring a tribunal on behalf of a claimant, even if the claimant wasn't going to. So if they're seeing wrongdoing in an organisation, they will have the powers to do that. When we think about tribunals, we're going to see the doubling of time limits. So currently an employee who wants to bring a claim for unfair dismissal, they generally have 3 months in which to act, but that's going to double to 6 months. That reform's coming in not before October 2026, but it's going to double from 3 to 6 months. So for you as an employer, it means a much longer period of uncertainty after a termination. You'll need to keep evidence, notes, records for twice as long, and a claim could now land on your desk half a year after the employee has left. So it just has that extra burden on employees to carry that weight of, are they going to claim? Are they not? We then have another fundamental and significant change, and that's the rules around who can qualify for claiming unfair dismissal. Everybody's been talking about it, and because it is so significant, currently somebody needs 2 years qualifying service to bring a claim of ordinary unfair dismissal, but that's been reduced to just 6 months service. The government's own estimate suggests this will grant protection to an additional 6.3 million workers. And what it's going to do is effectively turn the first 6 months of employment into a high stakes window. Because if as an employee you haven't identified and addressed performance or conduct issues by month 5, then you're looking at much, much more complexity and potential expense and legal processes when it comes to exiting an employee. It's not saying obviously you can't dismiss people, it just means the legal test and burden for employers is going to be so much stronger that it's got to be compliant to be able for you to be able to defend any unfair dismissal claim. And another significant reform, which perhaps hasn't necessarily got the press perhaps, but actually it's really one to keep on your radar and consider seriously, and that's the removing of the cap of the compensatory awards for unfair dismissal. So currently they're capped at either 1 year's pay or around 118,000. So we know there's a specific framework when it comes to calculating. If we're working in settlement agreement conversations, it helps us in those thought processes. But from January, that ceiling is going to disappear. Tribunals will be able to award compensation based on the actual and future financial loss of the employee. And why it's so significant is where it will impact those who are high earners or senior staff or individuals in very technical roles that have high salaries associated with them, because actually now an unfair dismissal claim could result in massive payout that far exceeds anything we've seen in the past. And that's why it's going to be really important, because it'll impact on how you handle settlement discussions and things like that. So the old strategy of sometimes taking the hit on a low process dismissal is going to become incredibly dangerous. That, alongside the Fair Work Agency's spot checks, uncapped tribunal awards, it just really emphasises the needs for having robust procedures. They're not optional, they're mandatory, and having that trained line management in place, because as I said earlier, they're your front line. They are the ones that are responsible for implementing and managing your policies. You might want to come to our next webinar, actually, because in April we're going to be talking about the new unfair dismissal reforms in further detail. So there's a QR code there, so it'd be great to have you join us and come along, because as I said, it's such a significant area of change. So we're coming towards the end of this particular section, so I just want to sum up some calls to action for everybody. First of all, if we think back to the harassment, we actually do have a toolkit on our doc shop. So that toolkit includes the bullying and harassment policy, a risk assessment for the prevention of sexual harassment, and an action plan. So do check that out. We also encourage that you conduct a workplace risk audit of all your working practices that are going to be impacted by all of these reforms, review and update policies, procedures and handbooks, review your internal communications and worker voice communications. Remember what I was saying about trade union recognitions. If you're able to give your employees what they want and need through direct discussions between you and them, that is going to take away their urge or need for having external help come in to facilitate discussions. Audit employee records and review your data retention policy. Training your line managers is critical and sooner rather than later. And don't forget, training needs to extend to also your HR teams, your payroll teams. Some of these reforms we're seeing are so significant that we haven't seen in HR in decades. And so it's really important that your HR teams are also clear with what is happening. Review and strengthen your absence management procedures, review and update your family leave policy, as well as your whistleblowing policy. And things like redundancy processes, making sure those are robust, because as you'll see from the handout that comes with it, one of the changes in April next month is the failure to collectively consult appropriately will now attract the double protective award. So instead of 90 days pay, it'll be 180. So that's our sort of summary in this particular section of urgent steps for employers. And what you can find there on the QR code is a link to how you can get access to contracts training policies and procedures. Now, I know some of you on our seminar today are members of our knowledge base. So really, this is just to let you know the latest. The documents we have ready for the April reforms, you'll see I've noted on the slide here. So basically, the hard work is done for you already. We've updated our employee handbooks, family leave policies. They're ready to download now. They're drafted to include the April 2026 changes. Obviously, we'll need to update them again, ready for October and again next year. So do check those out. And as a knowledge base member anyway, you get an email at the end of each month telling you what's been added, removed, changed to the portal. So check that out moving forward. And then coming soon, as I said, October reforms will be updating the risk assessment in the prevention of harassment and broadening it to all forms, and we'll be updating our tipping policy. For those of you on our seminar today who are our clients, we are working behind the scenes very hard, ensuring and getting your templates all amended for you. So do bear with us on that. And if you aren't yet a member of the knowledge base or a client, then you want to save yourself some time, then do get in touch with us after the event and we can see how we can help you get your business ready. So I'm going to pause for a moment. I'm going to hand over to Sue because we're going to just do a quick pulse, see how everybody's feeling.
So yeah, it genuinely is. How are you feeling at this point? This point in the year, week, day, having heard all of that, and we've still got more to come, obviously.
Yeah.
So yeah, it's just understanding how you are finding all of the changes, and I can see from the questions that are coming in, lots of them, some of the concerns that you have and are sharing. So yeah, we're definitely not going to be able to get through all of them, but we will certainly cover some of the key ones and cover some of the key ones afterwards as well. There are some similar questions, similar veins. Just leave that a couple more minutes. Seconds, sorry.
Yeah. It's quite good to get a feel for how everybody's feeling, and like I said, or you said at the start, it's just knowing that other people are in the same boat. Sometimes there's a little bit, oh, this is not just me kind of feeling.
Yeah. I'm just going to share those results. There we go.
So how are we all feeling?
Apprehensive, yeah, the majority, and I think we all feel that the increased costs and the admin burden, there does seem to be a huge amount of additional burden on employers, and bringing so many changes in such a short space of time. One of the perhaps several people have commented, at which point do we update our contracts? Do we have to keep updating them? We've had this debate, haven't we, Victoria?
We have. We have. It's really challenging. Really challenging on that.
Careful you don't breach current legislation by introducing future legislation too soon. So you can't actually jump the gun with contractual changes too soon. So
Because, yeah, technically, when you issue a contract of employment, it has to be accurate.
at that point in time, doesn't it?
Yeah. Yeah.
So some of it could potentially be done via a variation. Some at points where we're doing significant changes, it might be reissuing the contract, depending on how good your contracts are, up to date your contracts are already. If you've kept them pretty much in line, then you may only need to do variation letters to vary just specific term or terms. But if it's a significant number of areas you want, or you want to take advantage of the opportunity to review everything, then you could be issuing more than one change. Okay, I will
Thank you.
try that one. There we go.
So actually, probably now is a good opportunity to take some of those questions then, Sue.
Absolutely. So first of all, there's been quite a few questions around the bank holidays, and I just thought I'd clarify for you. The government haven't awarded more bank holidays. It's all to do with Easter. The way Easter falls this year across in April, and next year it's in March. So we have 2 Easters in the same holiday year, if you have an April to March holiday year. So for the England and Wales, we have 10 bank holidays from April to March. And bear in mind, the impact is there for the following year as well, because that means you only have 6. So the contractual implications could be the other way, in that you might be saying they're entitled to 8 bank holidays, and actually there are only 6 in that holiday year. So you just need to consider how you're going to deal with it and how you need to deal with it contractually. We've been asked about Northern Ireland. It's the same in that you may have more holidays originally. So I think it's 12 bank holidays in this year, and therefore there will be less the following year because of the way Easter falls. And Scotland is the same. I think it's 11 for Scotland because they have additional days or slightly different bank holidays to England and Wales. So the impact is across the country, all the countries in the UK, and but the number is slightly different if you're in Scotland or Northern Ireland.
Yeah.
So I thought I'd just clarify that before.
Thank you. No, that's really helpful.
A lot of questions around that, the one of the questions we've had is around, or a few of the questions have been around the sexual harassment piece, and this all reasonable steps. I mean, we found it before, didn't we, that it when we talked about it on previous webinars, that it's this all reasonable steps is quite a concern for people. So how do we know, is one of the questions, when we've taken all reasonable steps?
It's so hard, isn't it? And I think I mentioned earlier about reasonable isn't generally defined.
Yes.
But I guess ultimately it's down for that tribunal judge to make an assessment of the facts, of the circumstances. So what one business does that differs to another could be completely different. And we do have case law that helps guide us. And I think it's Caniff versus East Riding of Yorkshire Council, where they've set the legal test. So we know the legal test is 2 stages. So first of all, as an employer, you need to basically be able to show and say what steps you took. That's probably the easiest part of the test. The second test, and it's always the second hurdle of the test that's hardest, is were there any further steps that may have reasonably been taken, but you didn't? And if you answer yes to that last hurdle, then your defence will fail. That's what we know from that particular case ruling I've just referenced. So could you have done anything else reasonably? And this is why I said it's ultimately for the tribunal to judge what's reasonable. And I think the regulations that will come in next year will help, as well as having existing case law. And in fact, we're going to talk about a piece of case law later to illustrate. But it's really difficult. It's basically not leaving any stone unturned.
It is, and to the link with that, as we've had some questions around the equality training. How often should that be? And I guess this is linked with the all reasonable steps.
It
What
is.
is reasonable in how often you should train people?
Well, yeah, I mean, it's a given. Training is, if there's no training, then I'd say your defence will fail. So, but that's the first thing. But even if you've got training, it could still fail because there is an element of it's got to be fresh. It can't be stale, and we know that from a recent case law in LA versus Gellin. So training is a fundamental part of any employee's defence, and in that particular case, the fact that the training that they delivered to the workforce was 2 years old meant that they failed in that second of the two-step hurdle I've just said, because basically the training that was 2 years old was now stale. So how, therefore, effective is that training? Well, clearly it wasn't, because harassment occurred, and therefore they could have reasonably taken extra steps but didn't, and that reasonable step would have been refresher training. So I think as a minimum, yearly, definitely, but don't rule out the need to do it more frequent. Say, for example, there's a cultural change. I don't know, say, for example, there's a new manager that's brought in, and there's massive changes to the workplace culture in terms of, I don't know, behaviours, and then suddenly you're getting lots of claims and around harassment or sexual harassment, then that's prompting you to carry out a reasonable step of refreshing your training. So I'd say minimum annually, but recognise you may need to do it ad hoc on the back of something perhaps happening or any changes, if that helps.
Thank you. There's quite a lot of questions around the third-party harassment for events and things like that. One of them is, if you're the organizer and of an event, and at the event 2 people outside of the organisation have a harassment issue, is the organizer responsible? I guess we're into sort of slightly outside of HR grounds here, but there is potentially, because it's your event, you are responsible for the safety of the people attending that event.
You mean if somebody that's not your employee is harassed?
Yes.
You mean?
Yes.
Interesting.
But it's at your event. Yeah, I guess it's if it's maybe the catering team that's outsourced, perhaps. Or, and it depends as well if they're being harassed by a member of your staff, or whether it's I guess it all depends on the circumstances and where it happens. If it's at the event or if it's backstage in an area that's not the event's not responsible for. So I think it's a little bit context specific as well, but potentially, and this is why you do a risk assessment.
Yes, so it's understanding who the recipient is of that behaviour. Are they your employee, or are they another organisation's employee? If they're the employee of another organisation, then that organisation, we are their third party if we've done it.
Yeah. Yes.
If you know what I mean.
Yeah, exactly.
Yeah.
So I say it depends on the context and who's involved. Yeah, there's a few questions covered by the sick pay. So I think actually at this stage we will I'll collate some for the next session.
Yeah. Okay.
But for now let's continue with the sort of case law section.
Yeah. Okay.
Okay. Thank you.
Brilliant. Thank you. Really good questions. Thanks, everyone. So we're going to move on to looking at some key cases, quite interesting ones over the last year. And we're going to do things slightly different today because we want you to be the judge. We're going to be using polls. We're going to be giving you some facts and the circumstances, and then we want to get your thoughts. So you can practice being an employment judge for the day. So let's get the first case ruling up, and it's to do with managing statutory employment rights. And I guess this is going to be helpful because obviously what we've been talking about for the last hour is changes to statutory employment rights. So let's get the facts. And it's a case that is involving a long-serving employee of Royal Mail. And she'd planned a 4-week trip to Poland, visiting relatives with her children. She'd requested 2 weeks of unpaid parental leave to already approved annual leave. And her manager actually initially refused the request verbally. There were concerns around having too many people off, the impact obviously on the company's ability to deliver its service. The situation was then complicated because there were significant delays. So after she'd verbally requested her leave, parental leave, and it was denied, she then submitted a formal written request, but didn't actually get a response for several weeks, despite chasing her manager several times. And then I think it was 38 days later, the manager formally refused the request. He did, however, offer alternative dates, but these alternative dates were during school time. And obviously she was wanting to go and visit relatives in Poland with her children. So ultimately these alternatives made them useless. She appealed, raised concerns on that, and Royal Mail did admit there had been delays. But actually the refusal still stood because the department simply couldn't cover the work while she would be away. Now the individual actually found colleagues that she could secure shift swaps with, and so she actually did end up taking the trip. But because of the procedural failures, waiting 38 days and things like that, it actually caused her significant stress, and she was signed off for 3 months with anxiety and depression upon returning to the UK. She then submitted a claim at tribunal under the Maternity and Parental Leave Regulations of 99, also known as MAPLE. And so what we're looking to know from you in our poll is, and appreciate, if you don't know the case, which way do you think the tribunal ruled? Was Royal Mail in breach of the regulations, even though she had the time out to visit family, or not? Let's see what the poll. Is the poll loading okay?
Yes, it's not. It's distributing at the moment.
Okay.
There we go. It's coming through. Okay, let's give it a couple of seconds. Okay, I will close and share those results now.
Okay.
There we go.
Brilliant. Okay, so what have we got? 71% of you say there was a breach of the Maple regs, 29% of you said no. Let's see who's right. So 71% of you were correct. The ET actually ruled there was a breach of the regulations. So under those specific regs, if an employer wants to postpone parental leave, they must serve a written notice to the employee within 7 days of the request. But Royal Mail in this case took nearly 6 weeks. And the tribunal ruled that because they missed that 7-day window of responding, it meant they legally lost their right to postpone the leave at all. And this meant that by blocking her dates, they had unlawfully prevented her from exercising her statutory right to parental leave. So the impact of this procedural flaw was significant. While she eventually managed to get the time off, trading shifts with colleagues, the stress of the conflict took a toll on her. Now, the tribunal noted that while she was already struggling with her mental health, the company's handling of the leave request and the manager's refusal to even apologise for any delay was found to have significantly worsened her condition. And so I guess the key learnings of this case for employers is when it comes to the management of family leave situations is that time limits and technical matters of the law are vital. Even if there's perfectly valid business reason to deny a request, and in this case, there was that genuine reason of staffing shortage. How can you deliver the service? But the regulations weren't followed. The obligations on the employer did not happen. Procedural compliance is not optional, it's mandatory. So in this case, the individual was awarded £3,700 in compensation for their unreasonable postponement and prevention of her parental leave. So that's a really interesting case. As I said, it just brings home the importance of ensuring compliance with our entitlements, especially with them changing with the forthcoming ERA Act. So we're going to look at a second case, and this is a harassment and sexual harassment. So very topical, given the focus on addressing sexual harassment in the workplace under the Employment Rights Act. And I'm just going to give you the facts and circumstances. And you may have heard about this at the time, but it's in case involving a worker who was a customer assistant and then promoted to a shift manager at Lidl. However, unfortunately, during her employment, she was subjected to persistent and unwanted sexual conduct, primarily from a deputy store manager. It included highly inappropriate comments about sex lives, her physical appearance, and shockingly, it was found that the male staff even operated a ranking system to grade female colleagues on their attractiveness. I mean, how this happens in this day and age, I just struggled to get my head around this case. Beyond verbal abuse, Miss Hunter endured frequent unwanted physical contact, including touching her on her bottom, her waist, and it continued despite her repeatedly asking for it to stop. And one of the most damaging aspects of the case was the employer's response. She didn't stay silent. She made several verbal complaints and a written one. However, her managers chose to ignore or dismiss her concerns, even telling her she should take it as a compliment. So just a few further facts. Alongside the harassment, she discovered she was being paid nearly £3,000 less than her male counterparts for the exact same role. And when she raised that pay discrepancy, the business again failed to take any corrective action, leaving the issue completely unaddressed. And then in 2021, it reached a breaking point because she was called to a performance discussion about her lateness. She attempted to explain some mitigation around her lateness, connecting it to her ongoing harassment, the stress she was under, but they were ignored. And so as a final straw, she resigned, citing a total breakdown in the relationship of trust and confidence with her employer. And so she submitted claims, sexual discrimination, sexual harassment, and constructive dismissal. So what we would like to know is, if you were the judge, was she successful in any of her claims, and if so, which ones?
I think it's still distributing. Should be with you any minute. There we go. They're coming through now. Okay, I will close and share those results. There we go.
Okay. Yes. Well, before we move on to the next poll, just to clarify, yes, all of them, in fact. So she was successful for the sex-based discrimination, for the pay discrepancy. So the Employment Tribunal rejected Lidl's claim that the £3,000 pay discrepancy was a mere administrative error, finding it to be a successful case of sex-based discrimination. When it came to the can't get my words out, sexual harassment claims, then obviously the tribunal ruled in her favour again. There was a culture of harassment. A store environment existed where unwanted touching and the ranking of female staff by attractiveness went entirely unchecked. The impact over intent, so the T clarified that behaviour constitutes sexual harassment based on its impact on the victim, regardless of whether the perpetrators intended to cause offence. And there was a failure of reasonable steps. So at the moment, just remember the law at this point is reasonable steps. Lidl's defence failed because it lacked adequate risk assessments, failed to follow its own anti-harassment policies, and provided insufficient training for staff and managers. And then the final claim around the constructive dismissal, well, that cumulative effect of ignored grievances and the mishandling of pay queries constituted a fundamental breach of contract, justifying her to resign. So that's a really interesting case, and it just brings home the importance of procedures in preventing sexual harassment. So we've got one more poll here. I'm intrigued to know, in fact, we've got two more polls, but the next one we have is, how much do you think she was awarded in compensation?
I think that's just distributing.
Okay.
Oh, here we go. Okay, just give it a couple of seconds.
Okay.
There's quite a lot coming in at the moment. There we go. I will close and share those results. There we go.
Yeah. Wow. Yeah, and 44% of you would be correct. She was awarded £50,884 for her claims.
Surprised it's so low, actually. It feels low.
I can't get over the circumstances and what she was exposed to. It just baffles me. I mean, I don't know whether I'm naive, but horrific.
Absolutely.
So we're going to do one more poll in this section, and it's really interesting, actually. So the question to you is, could any other action be taken against Lidl?
That one's launched, I guess.
Okay.
And that the point of this is to understand that all of that could have been fixed by processes, and implementing policies. And we talked earlier about how often should you have harassment training and things like that. You know, clearly in this case, more often. But it's also just by not having processes in place or not having reviewed them recently to make sure they're still appropriate for your circumstances, for your environment, then it's not just the claims at tribunal. You know, you need to think about the wider context and implications of this for Lidl. Obviously, their reputation is at stake here, because tribunals are very public. So there's a much bigger impact of claims against a company, especially when they could be addressed so well through taking some action. So I'm just going to close and share this one. So yeah, the majority are saying 91% saying it could be. So are they right?
And this is interesting. Well, yes, you are. And in this case, what actually happened was further action was taken against Lidl, and the Equality and Human Rights Commission intervened. And what that meant was Lidl was brought into a legally binding agreement to overhaul its internal culture. And what that meant was they were required to monitor and analyse, so implementing a robust system to track formal and informal harassment complaints. They were required to have internal audits, so conducting regular staff surveys to assess the prevalence of sexual harassment. They were required to overhaul their policies, review and update all harassment policies and training materials, and the integration of equality, diversity, inclusion. So involve EDI inclusion groups, informal risk assessments. So that is a real tough case, or really sort of hits home the seriousness of it, and actually the financial implications of like Sue said, not having the right procedures in place, timely information, you know, so really interesting. So I'm going to just move the slide on because there's a brief summary on here. So like we've mentioned, the harassment culture, the intent of the actions, the failure of the reasonable steps, particularly key given what we're going to be seeing moving forward, constructive dismissal and the equal pay. We will have a handout, by the way, on our case rulings that do go into more detail. And then this is the last one in this section, and this is about religion and belief discrimination. So let's run through the facts here. So you had a Christian social worker offered a position at a charity which actively promoted LGBTQI+ inclusion. However, the charity reconsidered the job offer because they discovered online reports about the applicant's previous legal battle regarding Facebook posts, because he had previously shared his views and beliefs around homosexuality and same-sex marriage, citing them as sins. So the charity initially withdrew the offer because their views was that it conflicted with their core values. But what they did was they granted him a second interview to see if he could respectfully support LGBTQI+ service users, but they ultimately stood by their original decision to withdraw the offer. They say he was confrontational in that second discussion and failed to provide the necessary professional assurances that he would respectfully support their service users. So what we'd like to know is the first poll. So we've got a couple of polls, but the first one is, did the charity have the legal authority to withdraw that job offer? What do you think, yes or no?
They're coming through now. Okay, I will close and share that. There we go.
Okay.
So 73% thinks yes.
Well, in the particular circumstances of this case, they didn't. And I'm going to come on to explain, but I think we've got the next poll to follow up immediately after, and then I'll go into the reasoning.
Okay.
So what claims will he have had?
I think it's just
quite a complicated one, but I'll explain as we go through.
It's and we do get asked this at times when with you know, when the employer is challenged on whether or not to withdraw an offer. It is a big decision. It is a really tricky one. This particular case is quite tricky, but it does hopefully highlight the importance of not taking the decision lightly. So I'm going to close and share the results of this one. It's quite an interesting variation here.
Okay, so religious belief is a protected characteristic, 80%. Yeah, okay, so in terms of these particular circumstances, the discrimination claim will be the one that's based on his protected characteristic of religious belief. although, just to clarify, it's yet to be determined, because initially an employment tribunal ruled that the charity was justified in withdrawing the offer to protect the vulnerable clients, service users. The case was appealed, and what the Employment Appeal Tribunal outlined was actually the first tribunal failed to properly distinguish between the candidate's internal beliefs and how he manifested those beliefs. So manifested is part of a legal test, and the handout that accompanies this will clarify a little bit more. But these two elements were not properly separated in the initial tribunal ruling. And so what the tribunal, Employee Appeal Tribunal, has done is sent the case back to the Employment Tribunal. So it's going to get re-examined, but basically it's about whether, because ultimately you might hold a particular belief, but does it allow you to be act in a way towards somebody that would harm somebody, or from a negative point of view? So that's what the manifestation test is all about, that the ET will now need to consider. Just to confirm on the other responses around the sex-based, gender, unfair dismissal, breach of contract, he couldn't claim unfair dismissal because he was not an employee and therefore didn't have the 2-year service, which obviously is coming down to 6 months from January, but he's not an employee. He possibly could have a breach of contract. We don't know all the facts, but potentially it depends on whether a contract of employment had formed at that point in time, because ultimately that's where then he would be due notice, etc., for withdrawing any offer. But the actions itself of withdrawing the job offer have the potential to be discriminatory on the grounds of protected religious belief, and that's what needs establishing now back at the tribunal. So
wow,
it is quite technical and quite intense, and the handout will hopefully help it. But this is significant because it's how we interpret discrimination law. So it's whether how he manifested his internal beliefs, they weren't properly examined at the tribunal, so they need to re-examine. Any thoughts, final thoughts from you, Sue, before we go to some quick pulse checks?
I don't think so. I just think it's really interesting how it seems quite, you might feel like it seems quite clear at the time. You know, because you're involved, to you feel like, well, this is, I'm really, really concerned about this, which is hence the, you know, quite rightly they were concerned that it might have an impact on their service users. But they did try to consider whether or not there was that impact, and I guess it just shows the lengths you have to go to again here to be really sure, and particularly the manifestation test, you know, whether that really does have an impact, whether it's just your personal feeling and concern, or whether actually is there a genuine risk, or that it could have an impact. So yeah, I just I thought it was quite eye-opening, this case, in terms of the lengths you go to, isn't it?
Yeah, absolutely. So I'm going to just run a quick poll. Well, there's 2 quick pulse checks. Really, do any of these rulings surprise you?
They're coming through now.
Yeah, interesting.
It's interesting.
Really? Yeah.
We've had a comment come through that says, would it have been different if there was a section on the job advert that said offers may be withdrawn?
Interesting. Oh,
Mm.
well, a job advert can form part of a contract, for example. Your job description can. So I guess if you're communicating with somebody about the terms of an offer, I guess it could be incorporated in any argument that you try and form at a tribunal.
But you still have to have a full defence
Oh
for
yeah,
why
yeah.
you're withdrawing. So I
Oh
think
yeah, yeah.
I think it may or may not, depends on
I guess it's a
what's,
side issue, that piece, isn't it?
yeah, in a way, and you need to be careful that it doesn't actually detract you from the issues at stake. So there we
Because
go.
the issues at hand is about whether the beliefs could harm others. So what have we got? Yeah, the job offer withdrawal case did surprise half
Us all, I think.
Yeah. Interesting. And then just another quick pulse check is about, now we've gone through those 3 rulings, has it made you think about any immediate actions that you think you need to introduce into your workplace or think about?
Yeah, it's just distributing, but this is around policy creation or review or communication, the culture in your workplace, and risk assessments, action plans, things like that. Hopefully that's landing in your panel now. There we go. Yeah. Okay, shall I?
Yeah. What results do we have?
Close and share that result. There we go.
Yeah, it's good to see that there's takeaways for people from today. Some actions you can go away and look at. Communication of policies. Yeah, brilliant. Thank you. Thank you everybody for participating. So I'm going to move to the next piece, which is about 2027. And so this slide is just reflecting of the white box at the end is about 2027 onwards. So obviously I've touched on the 6-month qualifying period, the unfair dismissal cap award. Clearly we can't go through all of them, but what I have picked to go through is a massive reform to do with fire and rehire, or when you vary somebody's terms, conditions of employment, because it's going to be significant. So fire and rehire is a practice of unilaterally changing an employee's terms and conditions of employment. And so where negotiations fail, what typically happens is an employer forces through changes, and what they do to do that is terminate the existing contract and offers a new contract on the lesser favourable terms, or hire somebody else on similar terms. We had a ACAS code of practice introduced last year or the year before, setting out the necessary steps employers must follow when seeking to change. And so at the moment, employers can pretty much manage their business, contractual terms, so long as that fair and thorough process is managed. But we saw in the P&O ferries issue probably 3-4 years ago, when they made those mass redundancies of like 800 employees, that the government wanted to change the practice of fire and rehire. So now what's coming in from January, expected, is the employer's ability to modify contractual terms will be significantly restricted. It's going to make any dismissal that happens where the employer tries to push through contractual changes but doesn't get the employee's consent or agreement as automatically unfair. So automatically unfair dismissals, you don't even need any qualifying service. It's a day one right. And it will become an automatic unfair dismissal if the employee is terminated for refusing to agree to a restricted variation of their employment contract, or the employer replaced the employee with another person or offered to rehire the same employee under a contract containing a restricted variation to perform substantially the same role. We do know that there is going to be an exempt clause expected in the regulations for employers that can prove a contract variation was necessary to address financial hardship. However, a word of caution, it is literally going to be for scenarios where it can either make or break the ongoing running of an organisation, the financial difficulties threatening the viability of the operation. So whilst there is an exception clause, it will be still very, very hard to push through and force through contractual changes that are to do with these restricted variations. So of course, we don't know the full details. We have some indications of what expected restricted variations are likely to be. So paying time off, remuneration structures, pensions, working patterns and flexibility clauses. There needs to be that public consultation, get everybody's thoughts from, you know, trade unions, employers, professional bodies, all contributing into that consultation. And then from there, the government analyses the responses and will draft the regulations and a new or revised code of practice to be issued. But it'll centre around, you know, if you're trying to change holiday leave entitlements or how you calculate somebody's pay, or if you're varying pensions or wanting to change shift times, working hours, all of these things are going to be likely to be included as restricted variations. And so what the law will say is, if you try and force somebody to accept new terms and the terms you're changing are any of these and the employee doesn't agree, but you still dismiss them, it's an automatic dismissal. Or even if they feel the need to resign as a result of your actions in trying to push something through, then remember, resignations in those scenarios are dismissals, constructive dismissals. So it's going to be an automatic and fair dismissal. We are going to be running a webinar in June on this. Hopefully we'll have more information, but we're definitely going to be doing this in June and going through some details. You know, what does meaningful consultation look like? What strategic alternatives are there for employers? You know, how can you manage the business case for change? So do sign up to that. As I said, that's in June. And then just to bring this section to a close, just some call to actions again. Review your current variation clause in your contracts now. Is it robust enough for you to make changes before the rule changes? Review your current contractual terms in the context of the new employment landscape. Are changes necessary? And what we would say is, if through all of these reforms you're thinking actually we need to revisit our pay and reward strategy and therefore some of those terms are contractual, we need to change them, changing them sooner rather than later is your best course of action, because you've got more flexibility as an employer to make contractual changes. Of course, you need to assume following that fair ACAS code of practice and fair processes, but it's much easier to do now than from January onwards. And then ensure your HR teams are fully trained on the reform and the implications of managing these situations. So let's see where we are now with questions. Now's a good time to just hand over to Sue again, see what sort of questions we've had in.
Okay, so interestingly, there's quite a mix of a little flurry in the last few minutes. Just on the last subject, is would it include, or is it likely to include, I guess is all we can ask at the moment, changing notice periods? And my initial thought was, if you're changing it to make sure you're in line with statutory minimums, then you have to do that anyway. There's a legal obligation to ensure it's up to date. But if it's from a company stance, depending on how you are changing the notice periods, then I guess it could well fall into this, and better to do it sooner rather than later while you're making all these current changes and updates to your contracts. That's why we're saying think about it now. If there is a change you want to make, for operational reasons. You still need to justify it. You know, you've
Yeah.
got business operational reasons because you need to still gain agreement even now, even though you can still potentially enforce it, but with caution.
Yeah.
So yeah, that I think that's it could
That's
well
quite a
fall into
significant thing,
these.
isn't it? Yeah.
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 And it depends what you're doing. Are you making it harder for people to leave you, or are you making it less onerous? So I guess it depends on what you're changing.
Yeah.
The statutory minimum notice period, just been asked to clarify it. It's 1 week per year of service to a maximum of 12 weeks.
Yeah.
So so those are the statutory minimums. You can have, you can exceed that as long as that is your minimum, and a lot of people do exceed it or vary it slightly. So sorry, I just lost my train of thought then. So there's a couple of questions around tribunals, and they were linked with the fact that, not tribunals, sorry, trade unions.
Yeah.
Is it really the case that if, say, you have 10 people have voted and 2 decline but 8 want it, that it's just automatically carried, even if you've got 50 employees in your company? Yes.
Yeah.
I'm guessing that is the
Simple
case.
majority. Yeah.
Yeah, it is a simple majority. Equally, if 6 vote against it and 4 vote for it, out of the voters, if that's a majority out of the voters, then it won't get carried through. So it will be important that the whole company participates in the voting, so you're getting the whole company's perspective on it and not just the people who are interested in bringing it in, which is the case before. So yeah, that is there anything else I've missed on that one, Victoria?
No, I don't think so. But yeah, there's so much going on with the trade unions.
Absolutely.
It's a very technical area of the law, which is why we recognise a webinar would be welcomed, I think. So we're going to spend time on it soon.
And it's also, you know, the point is that no employer can ignore this change. I mean, traditionally those who are thinking, well, they're never going to try and bring it in here, I'm not going to worry about it. But actually, every single employer has to include it in their contract of employment. We haven't got the wording yet, but once we do, we will make sure we have to include it. You know, the specific wording that will be provided. It's going to be specific wording they're providing as well, isn't it?
Yeah, that's right.
Will need to be included. So so yes, so that was the sort of issues around trade unions. And then the other area is another area we're going to cover in more detail is probation periods.
Okay. Yeah.
One was, if you extend a probation period by 1 to 3 months, does that also extend the 6-month qualifying period?
No.
And no, exactly. So extending the probation period is at the risk of the employer, which is, I mean, we're going to have a whole session on probation periods. We did run one last year, but we are going to run a refreshed one next month.
Yeah.
With the latest information that we have. But it is going to be a significant change for people who have a probation period of 6 months or more. And somebody also asked, if we have more than 6 months, does that mean it doesn't apply? It means you could be in breach of the unfair dismissal when it's reduced to 6 months if you change your processes during the probation period. I guess that's the risk, isn't it? If you still manage everything the same, it's, whether they're in the probation period or not.
So yeah, so if they're in a probation period after the 6 months qualifying service,
yeah,
it means technically they can bring a claim for unfair dismissal for how you've dismissed them. So it places more importance and emphasis on having a robust fair and reasonable process in getting to that dismissal. So whereas you can still dismiss, it's just you have to have a more robust and fair process to show a tribunal for why you dismissed.
Yeah.
Does that make sense? Have I explained that? Is that what you were meaning?
Yeah, I think that's what they were asking. So and you can still have a probation period that goes beyond the 6 months if they're still not performing. It's just you have to be careful if the ultimate would be you may fail them and therefore dismiss them. So I
Yeah,
guess it depends on why you are not passing the probation and whether there's a likelihood you may want to dismiss. You can still do that, but you just have to make sure you didn't follow a lesser process
yeah, you've got to
during
show
the
you're
probation period.
reasonable. Yeah,
Yeah,
and explore alternatives so that dismissal is your very last course of action. But personally, I would advise in the new world not having a probation policy that takes over 6 months,
yeah,
because it just unnecessarily complicates things. If you can have a probation period, say 3 months, and allow for an extension, but make sure that extension and a probation is done and dusted by month 5, you say, then it just simplifies things for you as an employer. But yeah, it's going to be difficult. We're going to be talking about it next month in a webinar, aren't we, Sue? So
we are. Yeah,
do come along to that and let us have all your questions.
absolutely. So so another sort of contractual question is if you pay staff a price component for work, but it's not written on the contract, can it be changed? Or because it has been paid previously, has it already become contractual? So I guess we're into the implied terms territory here. So it depends how often you've paid it to how many people, and has it become a custom and practice? If
Yeah,
so, it's probably contractual now.
yeah,
So again, that's quite case specific, but possibly it already is. So there would be some element of risk,
yeah,
and you need to manage carefully if you were going to vary that.
yeah.
And something that we share very much with this contributor, given the volume of changes, is there a window of time allowed to ensure all relevant docs are, such as policies, are updated in the meantime, as long as you adhere to current legislation? I guess policies aren't contractual, are they? And they're not
No,
compulsory. But so there is a window, as you say, as long as your practices are compliant. But it depends on the size of the organisation as well, and how well trained your managers are, and if the staff understand the implications. As long as that's being communicated well, but
there's a risk.
ideally
Yeah, I
there is a
think there's a
risk.
risk
Yeah,
of confusion, and managers often go back to the policy for
yeah,
reminding them of what to do, what process to follow, or how to go about dealing with something. And so that's why, what you said about making sure communication, it's going to be vital, because you don't want anything happening because the clarity of information isn't there.
absolutely.
Yeah, good question that. But
Yeah, absolutely. we trying to get everything out for all of our clients in time for them to implement them. That is the pressure we're under, because we need them soon and in time to implement them as well. So
yeah,
yeah, we share the concerns. So yeah, it's quite a lot.
it is
I
a
mean,
lot.
it is staged in batches, the things that are essential now, and there's the things to plan for October. And what the challenge is really the contract, because you can't change it too soon. You could only change it in readiness for the new law. So it's working out, at what stage are we going to do it, and how soon. And when you're recruiting, you need to think about your recruiting. If you're recruiting from July onwards, did we work out? And you have a probation period of 6 months or more, you probably need to consider bringing that forward, because they could be impacted by the change come January, because they'll have 6 months service by then. So again, it's just considering impacts now, doing your impact assessments to sort of work out which policies you need to do urgently, and then the timing of any others, and contractual changes in time for recruitment that you might be doing in the future.
Yeah, and you raised a good point there about January is when the 6-month qualifying rule kicks in, but actually it's not from that point onwards. So anybody as of the 1st January has 6 months service, at that point they fall into scope. So you'll be managing processes now. I would imagine it might be performance management, it might be long-term ill health, or that you've got to consider the steps you take now have to be so robust and fair and reasonable, because if you're in the situation, say come January, of you're at the end of that process and you need to dismiss, then that you've got a group of people that currently don't have 2 years, but they will have come January. And so if that coincides with when you're closing down the process, they will have that right, if that makes sense.
Yeah, absolutely.
Okay.
So I think that's all the questions that we can deal with now due to the time. I just want to reiterate, just because of a few comments that we've had, just to remind you all, you will get a copy of the slides and a link to the recording in the next couple of days following the webinar. So yes, those of you who've had to miss it, unfortunately, one lady's missed it because of a fire alarm. So don't worry, it's all being recorded, and you will be able to watch back anything that you've missed. So yes, thank you all for your really good questions.
Yeah, brilliant questions. Thank you. So shall I move the slides on and we should get to the next part, which is coming near to the end. So this is really just to share our thoughts on what we recommend employees do to prepare the business for change. And we've got a list here. It is accompanied by a handout. And as you can see from the screen, there are lots of critical things to do. I would say a really important strategic tool is your people plan. So there's an image there in terms of one that we have on our doc shop that if you want to download for free, that's there available. And actually, if you go through all of these tasks, so doing your impact assessments, auditing your workplace practices, you can then start determining what actions need to happen when and the priority. So that's where you can use the strategic people plan to map out. So do get the time to have a look at that, and hopefully that will help you in preparing and staying organised for the next few years, because I can see this going on beyond 2027 if you ask me. So let's now take a look at some of the tools that we've got available to you. So we've got a HR risk audit online that's available. So we are going to launch the ERA dedicated one shortly, but do check those out. They're really good for assessing where you are in regards to your employment practices. I mentioned the knowledge base earlier in this seminar today, so that's just a reminder. It's our portal where you can find all your templates for anything to do with the employment life cycle. We have over 600 articles and guides to keep you informed on matters, and a lot of the template policies that I'm referring to, as I said earlier, are already on there ready for April. So that's our knowledge base. And then of course we offer training. So definitely we offer training around the employment rights changes, but also more specific training like managing performance, recruitment selection, leading the team, obviously priorities around the Employment Rights Act, so employment law, and then we do also accredited ILM courses as well. So we have a lot to offer in that regard. From a health and safety perspective, obviously there's many ways in which you can support your business as well, whether through helping support in fire safety, online training, delegated training. There is so much that we can offer there as well. And obviously training can be IOSH, mental health, first aiders and fire safety. Now, we always promote on our webinars how we want you to engage with us and keep in touch with us. Obviously, there's so much going on in the news with the Employment Rights Act. If you follow us on LinkedIn, then you'll just stay up to date with the news that's breaking. And obviously, you can sign up via our website for our news items and newsletters. And then obviously you can contact us, drop us an email or give us a call if you want our help or support in some way over the coming months. So do keep in touch with us. And finally, we've got 2 more quick polls that we would like to run. And would be grateful of your involvement and input in these.
It's really what kind of help would you, or information would you like from us? It's just distributing now. I think we've worn the poll system out today.
As long as we haven't worn the listeners out.
No, thank you to all those of you who are still with us.
Yeah.
We're nearly there.
We're nearly there. There's a lot to go through.
And yes, to the person who's asked, we do offer harassment training.
Yes.
There's definitely a course specific around the sexual harassment training as well, and the specific to the Employment Rights Act changes as well. Okay, I will close that one now. And then one final poll. It's just let us know if you'd like us to contact you. We're a typical HR company. We are very gentle. We won't bombard you unless you ask us to give you information. And thank you for your feedback as well that's coming through. Okay, I think we are just about there.
Yep.
Thank you very much.
Perfect. So, well, I'm staggered. 1 minute to go. And so thank you. I think this is the first time ever finishing on time. So we've got through all the work. Thank you everyone for joining us today. We hope you can join our future webinars. They run every month. Second Thursday of the month, 10 to 11. Thank you, Sue, for your assistance and support and conversation on these topics. Yeah, just thank you for everybody's time. I know everybody's busy, so thank you and have a good rest of the week, and we hope to see you on our next webinar. Thank you.
Thank you. And thank you, Victoria, as well, for all your input and all your hard work. Thank you.
Thank you.